Good morning. Welcome to the employment law video for ABUS 4013. Today we have a guest with us named Holly Robbins, and Holly is an employment lawyer in Minneapolis. She works with the firm of Littler Mendelson, which is a firm that specializes in employment and labor law, and they have offices across the U.S. and overseas as well. So thank you, Holly, for joining us this morning.
Thank you for having me.
So we have a top 10 list of tips for managers from an employment lawyer that we put together. And so we're going to structure our conversation today with following that list. So, Holly.
Yes.
Number 10.
All right.
Make sure your employees are classified and paid properly. What's that about?
So what that means is that employees are either classified as exempt employees or non-exempt employees. And employees who are non-exempt have to be paid overtime. They have to keep track of their hours. It's important to get that right because right now, this is a very hot topic with plaintiffs' lawyers to look for companies that are not doing this properly and to try to structure class actions where the plaintiff's lawyer can then find a bunch of people who all have been paid improperly and try to get the money back, and that attorney would get attorney's fees if they win as well. So there's an incentive there for the plaintiff's lawyer to try to find these classes of people. Now, there are also sometimes issues with independent contractors that feed into this area. Independent contractors, that has a very specific meaning. And often you may have someone who wants to fashion themselves as an independent contractor, and that may be beneficial to the company as well. But if they're not really an independent contractor, if they're really doing something that an employee would be doing and they're directed the same way that an employee is directed, then both for tax purposes and for wage and hour purposes, they really should be classified as an employee. And again, you see these class actions popping up that address these wage and hour issues with independent contractors.
Okay, so when these lawsuits crop up, they're saying, the plaintiffs are saying that they should have been classified as an employee that's exempt? No,
that
non-exempt.
Is non-exempt usually and should have been paid overtime.
Right. Yeah. So it's the overtime that they're looking to get.
It's the overtime they're looking to get, yes.
And it would be back pay for whatever period that the employee was not treated as a non-exempt.
Correct. It could be. Yeah.
And so when I think of a non-exempt employee, I'm usually thinking of someone who's a manager. Is that...
An exempt employee is someone who's a manager, so someone who's salaried.
Right.
And sometimes people want to think of themselves as salaried, and they get even insulted if you say, okay, we're going to change you from an exempt salaried employee to a non-exempt employee. But for the employee, there really is an advantage in that they're going to get paid overtime.
Right. So there's been some cases about that in the news recently with managers at a large retailer company, I think.
There have been a number of cases involving large retailers, restaurants, construction companies. It's really running the gamut of companies. I mean, sometimes even a smaller company, now they might not have a class action, but maybe they have someone that they're calling a salaried employee who is someone that they think of as like their executive secretary.
Okay.
But if that person really is doing mostly traditional secretarial work, they should be classified as non-exempt and they should get overtime.
Okay. So what are the main factors to decide whether someone should be classified non-exempt versus exempt?
It really depends upon the type of position, but a lot of times it depends on kind of the level of work that they're doing. So how sophisticated and complicated and how much control that they have over what they're doing in their job.
Okay.
With independent contractors, there are also issues of if somebody is only working for one company, is prohibited from working from another company by contract, that person probably isn't going to be classified as an independent contractor. And if they're directed very precisely in their work by the company for whom they're working, then they probably aren't an independent contractor. They're really a traditional employee. You should be taking out the taxes and paying them overtime if they're working more than 40 hours a week.
All right, number 9. Disability and leave laws are often complicated and unintuitive.
Yes. So there are a number of laws that protect people who have disabilities and also that protect people who need to take a leave because, for example, they're having surgery or they're having a baby or they had a baby. And so with respect to those disability and leave laws, they interconnect, first of all. Sometimes for a disability, you need to take a leave.
Right.
And the other thing that can be very complicated with leave laws is that intermittent leave is something that is provided by the federal statutes that govern disability leave. It's called the Americans with Disabilities Act. Right. And that allows someone to take time off intermittently. So they might be able to take off 2 hours a day every week because they need to, because their doctor says that they can't work the full day. Or they might need to take off 1 day a week to go get a treatment, to go get therapy or something like that. Or they may just need to take leave off intermittently without any kind of notice because they get migraines. And when they get migraines, they're unable to work. And that's just an example of the kind of condition that can be protected by the Family and Medical Leave Act, which is a federal statute, by the Americans with Disabilities Act, another federal statute, and also by the Minnesota statutes, the Minnesota Human Rights Act. So even if a company isn't big enough to be covered by the Family Medical Leave Act, which has certain requirements of more than 50 employees working within certain areas, they may be covered by Minnesota statutes. And in Minnesota, there's a statute that the law is actually changing on August 1st. And there is a greater opportunity for leave for people who are looking for parenting leave. Oh. So people who have just had babies, men and women, covers both, and or women who have conditions that are related to pregnancy. Okay. So they may need leave before they have the baby or after they have a baby because of a pregnancy related condition. The intermittent leave, I think, is something that's particularly complicated and often seems like maybe someone is cheating the system a little bit because it comes up sporadically. It's unpredictable, but people do have conditions that may cause them to need to miss work periodically because of that condition. Right. And frankly, they may not be safe to work when they're having a migraine or having an episode. It often comes up with mental health issues as well, which are protected under the Americans with Disabilities Act, the Minnesota Human Rights Act, and the Family and Medical Leave Act.
So it does sound really complicated. What do you advise people to do if they don't have someone who's an expert on this in their company? What would be a good thing to do?
First of all, you want to have a policy. Get your policy in shape. There are examples of policies online. You can work with an attorney to create a policy. Human resources professionals are often very knowledgeable about these policies as well. So have a policy and then follow your policy. But when you get those complicated questions, it is something that you probably want to consult with an attorney about.
Okay. And is it better to do that ahead of time?
Some of them are straightforward, I will say. There are some very straightforward issues. Yeah. But certainly, it's better to start when you realize this is too complicated and I can't quite figure it out. Or, if somebody is coming to you and saying, I need to take time off, I'm going to have a baby, it's pretty cut and dried. Okay, there's paperwork that needs to be done. You get that paperwork filled out. The paperwork is mandated by federal law, so you can find that again. It's online. The Department of Labor issues certain examples of that paperwork. Okay. And then the person gets, under the Family and Medical Leave Act, 12 weeks of leave. One thing to consider, however, is say someone has taken 12 weeks of leave off because they have cancer. And at the end of 12 weeks, they're not quite ready to come back to work. But they will be ready to come back to work at some point. Even though the Family and Medical Leave Act doesn't necessarily cover them for any more time, the Americans with Disabilities Act may. And leave is what's called an accommodation, a reasonable accommodation, or maybe a reasonable accommodation under the Americans with Disabilities Act. So under that act, you have to consider whether that person needs additional time as a reasonable accommodation. So I say it can be cut and dried, but it can also not be.
Okay. So if you have questions like that, it's worth the call to an attorney that has the expertise.
It is, because when companies get it wrong, they can be held liable for it. They can get a charge or a lawsuit under the Disabilities Act or under the Family and Medical Leave Act. And that's something you're better off making sure you do things right so that you can avoid that.
Okay, so we talked a little bit about policies in the last issue. Now, our number 8 top tip is know your policies.
Yes. So first of all, have policies.
Right.
And this doesn't mean you have to have a policy on every little thing, but there are certain things that it's really important to have a policy on. Leave is one of those things.
Right.
Because that's part of, at least if the company is large enough to be covered by the Family and Medical Leave Act, it's a requirement. You really need to have that policy. Another thing that it's really important to have a policy on is an anti-harassment policy. So that's something that says that that the employees of the company must not harass other employees, and managers must not harass employees on the basis of any protected status. So protected status, there are a number of different ones. It can be race, sex, disability, age, marital status in Minnesota, sexual orientation in Minnesota. Those aren't federal, but they are in Minnesota covered. Religion, creed, national origin, and I'm sure I'm missing some.
It's a pretty good list.
But there are a number of protected statuses, and all of those people are protected from being harassed. And the way that the law works is that having that policy and following the policy is part of a defense that a company would have. If, for example, someone complained and said, I feel like I've been harassed by my manager, having the policy that says, this is the person to whom you should complain if you have a problem. And when we get a complaint, we will investigate that complaint and we will take prompt and effective remedial action. And so if the company has that in effect, then they may have a defense if the employee fails to follow the policy. However, if the company doesn't have the policy, they lose that defense. Okay. So it's important to have that in effect. It's also important just so that if there's a problem, the company knows about the problem and the employees know, what am I supposed to do if I have this problem? How do I remedy it? And they're not just saying, okay, I think I'll remedy it by going and talking to all of my coworkers about it. That's my remedy. Mm-hmm. No, there's a specific way. Go to the HR person. That's typically the person that in the policy we would say, go to the HR person. If you don't have an HR function, then it may just be go to your manager. And if the manager is not the right person, go to the person above the manager. Mm-hmm. Ultimately, you can always go to the president of the company if you need to do that. Okay. So having that policy in effect is important. And managers should be familiar with those policies.
How does training for employees work into that?
Yeah, and the training is an important part there as well, because if the employees really have to know about the policies as well in order to be able to follow them. So certainly we recommend having training on things like the anti-harassment policy. With the Family and Medical Leave Act, there are certain posters that are supposed to be posted in workplaces, as I think there are with the discrimination laws as well. Okay. But the FMLA, things like that, that's the Family and Medical Leave Act. Right. That should be posted so that employees are familiar with the Family and Medical Leave Act. And there is actually a federal posting that's supposed to be up. And again, you can find it online.
So do clients ever worry, like companies call you up and say, if I train my employees, aren't they going to sit down and think of all these claims that they can bring? I mean, what do you say to that question?
It is something that I have heard employers say, well, we've decided we're not going to have any policies because then no one can complain and no one will know. And having policies just creates problems. I just really disagree with that because, again, if you don't have the policies, it doesn't mean that the problem doesn't exist. The problem may still exist, but it's just festering there. And eventually it comes out in a piece of litigation, which is going to be costly and time consuming and distracting, and you don't have your defenses in place either. There are, certain things that are mandated by federal law. The federal law doesn't say you have to have a policy, but it does say if you don't have one, you don't have a defense to the harassment cases. A big part of the anti-discrimination laws ends up being about fairness, and that people who are similarly situated, they're doing the same jobs, are going to be treated the same way in the same types of situations. So if you have one employee and they want to take a leave and you say, okay, yeah, you can take 12 weeks of leave and then we'll give you a couple more weeks after that and that's fine. We'll do that for you. And then you have somebody else who comes along the next week and says, I think I'm also going to need 14 weeks instead of 12 weeks. And you say, no, we're not going to do that for you. Then the question is why? And is it because one employee is younger and the other's older, or one employee is Black and the other is white? So the policies are helpful to help managers manage similarly in similar situations.
Part of our focus in this course is risk management.
Yeah.
And I think what you're saying about having the right policies in place is part of an overall sort of risk management strategy for, limiting potential liability, but also just making sure that we're doing things the right way.
Definitely.
Treating people.
And,
right.
A big part of risk management is having these complaint mechanisms so that when an employee has concern, that concern can be brought to the right person, and that person can manage that complaint, can do an investigation if that's necessary, or figure out who should do the investigation, and can take care to make sure that the situation is properly handled, that if there's a problem, there are prompt and appropriate remedial measures. Now, that doesn't mean employee complains and then the HR person to whom the employee complains has to fire the person that they complained about. No, the discipline would be appropriate to the particular situation, and situations have to be handled on a case-by-case basis,
Right.
But as I said, keeping in mind that similarly situated people should be treated in a similar way.
Great. We're going to switch gears a little bit now.
Okay.
Our number 7 tip is sometimes ignorance is bliss, but privacy is important.
Yes, and it's kind of funny because it seems like the flip of some of the other things that I'll be saying today, but there are certain things that managers should not be talking to their employees about. And that includes in interview situations. So, for example, you don't want to be asking in interviews about somebody, whether they're married, do you have kids, things like that. Those are things that can be a tip-off to agencies like the EEOC or the Department of Human Rights, that the company is looking for information that tells about someone's marital status. If they have kids, they may think, oh, well, that company is going to want to discriminate against someone who has children because they're going to think, oh, they have to go home. Or asking about, are you pregnant or do you have any plans to get pregnant? Just an absolute no-no in terms of asking interview questions.
Okay.
So those are the types of things to stay away from in interviews. And, I recognize that workplaces are places where people know each other well, and you're going to learn those things about your employees, and that's okay. But it is something that managers should be very conscious about not prying into. If an employee is closed-mouthed about their health, their family, etc. And managers should really stay away from those topics. Their religion is another one.
Right.
All things to be a little sensitive to between managers and the employees that they manage.
What about age? Is that something you can ask?
Age is another one of those things that you want to be a little careful about asking. You shouldn't be asking about age in an interview, and be careful about talking about people's age. People can be very sensitive about that. And, even the sort of joking around about, hey, old man, or, your birthday or what have you, those things can be very sensitive with people. And it's funny how they come up later. If, you're joking around about something about someone's age and that person ends up being let go for some reason, and they file a disability suit, all of a sudden you're going to see that time when you called someone old man in a complaint in a lawsuit. And that's very disconcerting and something that, you can avoid by just not doing that in the workplace. The other privacy issue that I want to talk about is privacy and health issues. The less managers know about this sort of thing, really, the better. If you have an HR function, things like leave should be handled through that HR function. And now, if a manager is told by an employee, hey, I need to take a leave, the manager should immediately take that information to human resources and have human resources deal with it. Now, if you don't have that kind of HR function, the manager will have to deal with that. But if you do, it's good to really keep that information separate. Similarly, even having your personnel file. Don't mix up the health information in the personnel file. Keep that information separate. If you, for example, have leave issues, or companies like construction companies, you may have physicals of employees. There may be health information that's related to making sure the person can do the job in the first place, and can lift certain amounts and is able to do the essential functions of the job in the first place. That information, again, should be kept separate and should be handled by human resources folks as opposed to the manager. If the manager doesn't know that someone, for example, has a disability, then the manager can't discriminate against that person because they have a disability. And, even if the manager would never do that anyway, that does create a very simple defense in a disability case to say, I never knew that person had that condition, so I couldn't possibly have discriminated against them. I did not make the decision to demote, fire, not promote, etc., that person because of a disability that I didn't know about.
So there can be situations where it's better not to know about someone's health condition, because it protects you from a charge that you treated them differently because of their disability.
Correct.
So for that to be effective, the health information has really got to be kept in a locked drawer, like really well separated.
It should be kept separate, also because it is private information, and shouldn't be accessed by other employees who have no need to know about it. Shouldn't be accessed by people from outside the company, certainly, who have no need to know about it. Health information is private and should be kept separate. Now, managers will have to know sometimes about conditions because they need to work with human resources and the employee in order to come up with, say, an accommodation.
Right.
So under the Americans with Disabilities Act and the Minnesota Human Rights Act, it's necessary to provide a reasonable accommodation that will allow a person with a disability to do the essential functions of their job. So if an employee can do the essential functions of their job with a reasonable accommodation, then the company should be making that accommodation. And there's always a question of what's reasonable, what accommodations will allow the person to do the job, what are the essential functions of a particular job. But those are things that employers, the managers and the human resources person and the individual's doctor all have a part in defining what that is.
Okay. Let's move on to number 6, beware social media.
Yes. So social media is obviously something that's interesting to people generally, and it contains so much personal information. And it contains so many messages that people put out into the universe when they're mad or when they're happy or when they're thinking about quitting their job or when they hate their supervisor or when they have been having a bad day. And people are not always, I'm sure we all know, people are not always very good about keeping their feelings silent, and can sometimes put things that are kind of ill-advised on the internet, on Facebook or Snapchat or whatever it is that people are doing. And so employers have an interest sometimes in saying, well, I'm looking at hiring this person. Maybe I should look at their Facebook page if it's not private. Or, this employee seems to be, I think that they're cheating on FMLA. I don't think they're really sick. I think they're just pretending to be. And so I'm just going to check out their Facebook. Another thing that happens sometimes is you'll get an employee who brings something in. I'm friends with Bob on Facebook, and I just saw that he's put up this rant about his supervisor and how the supervisor is being unfair and treating employees badly and harassing people. And I don't think that he should have put that up there. So I'm going to give it to you, Mr. Supervisor. And I think you should just know this. Now, Mr. Supervisor gets that information, and Bob has been ranting about him on Facebook. And Mr. Supervisor's first instinct is, I'm going to fire Bob. But the actions that people take on Facebook, the things they say on Facebook, can be what's called protected concerted activity, which the National Labor Relations Board says, well, if what Bob is saying on Facebook is something about the fairness at work that may apply to more than just Bob, and they're acting as they're reaching out to a group of people, that could be protected. So really, it's not always in the employer's interest or best interest to go looking on Facebook for things. As I said, often what happens is somebody else brings it in and makes the employer see it. And it's really hard to not think about the fact that Bob has been talking about you on Facebook, but it is something that supervisors need to be able to sort of separate themselves from.
Interesting.
That this employee is ranting about me on Facebook, but what he's saying is something about fairness and about treating people generally badly. Now, it doesn't mean that Bob can say on Facebook, I want to kill my supervisor, and that is protected activity. But you got to be really careful when you're looking at what people are saying on social media as to whether that is something you can actually act on. Similarly, when employers are hiring, if they're looking on social media to find out information about people, it may, again, tell them things that they don't want to know. It might say something about the person's religion or their national origin that the employer didn't know before. And you don't want your employment decisions to be tainted by those issues. So probably best to stick with the information that the employer knows, or at least be very conscious that if you are going out to look at what's on social media, that if you find out information that is about protected status, that you don't take that into consideration.
Okay.
And, I don't want to say you should never look on social media. I mean, there are some things that are about someone's professional background. LinkedIn seems pretty, that's supposed to be about someone's professional background. And if someone's resume on LinkedIn doesn't match up with their resume that they gave you, it might actually raise some good questions.
I mean, kind of common sense is don't put stuff on Facebook that you wouldn't want a potential employer to see.
Both for the employee and for the employer, because if you think about if you as a manager are putting information up there, then your employees might be seeing it. And that can have an effect on how they see you, depending upon what the picture is or what the message is.
Okay.
So, it may also be not the best idea for managers to friend their employees and to be in more social networks as opposed to professional networks with their employees.
Great. All right. Let's see. Number 5, listen to employee complaints.
Yeah. And this is a little bit something that we've kind of talked about up until now as
Yeah.
well, that when employees make complaints, supervisors have an obligation to act if they're making complaints about protected issues. If someone comes to a supervisor and says, I feel like I'm being harassed by this other supervisor or by this employee, then that's something that you want to really listen to. But it doesn't just have to be the word harassed. It could be, I'm really uncomfortable. This person makes me really uncomfortable. And that shouldn't be something that you go, oh, uncomfortable. Okay, she didn't say harassed. She said uncomfortable. So, well, I'm sorry about that. Maybe you should just stay away from him and then leave it at that. No, that's something you want to get into a little bit more. Now, the supervisor, again, if you have an HR function, this is something that supervisors probably should go to HR with and let them take the appropriate action. Again, they're the ones who kind of own those policies and can work with them and will know how they've been addressed in similar circumstances. So again, people can have that fairness. But supervisors really need to listen to what they're hearing, even when they're things that sound like little gripes. If those little gripes are actually gripes where the person's saying, well, I think this is illegal. Well, there's a Minnesota Whistleblower Act. The Minnesota Whistleblower Act protects people who have made complaints of illegal conduct. And so even if the person is wrong and nobody committed that illegal conduct, if they have a reasonable belief that someone did, that could be a protected activity. Now, you want to look into it. You want to treat it properly and seriously and not retaliate against that person for having made that complaint. Now, here again, it's sometimes the employers say, well, it's better just to ignore it because then, if I didn't know about it, if I don't pry into the situation, then I could say, well, I didn't really know. But there don't have to be magic words. It doesn't have to be the word, I think this is illegal. I think this is sexual harassment. I feel like I'm being discriminated against. If the words are more, as I said, I feel uncomfortable, or this person is really bothering me, or I saw this inappropriate, I saw naked pictures on the screen of one of my coworkers. That should be enough for you to say, okay, let's tell me about that and let's do something about it. Now, a corollary to this is sometimes you will get these kinds of complaints from employees who will say, this is confidential. I just want to tell you, I don't want to do anything about it. But if you're getting that as a supervisor, and this can be hard because sometimes your employees, you feel like they're your friends and they won't trust you. But if you're hearing about sexual harassment or illegal conduct or something like that or disability discrimination from an employee, you really have an obligation to look into that further, to take it to HR, to make sure that it gets addressed, even if that employee is saying, I don't want to do anything about it, because that puts the company, by them coming to you as a supervisor, it puts the company on notice and it creates the potential for liability.
So if someone does come to you and say, I want to share this, but it's confidential, should you right away say, I want to hear what's bothering you, and I may have to take action on that before they spill, or is that a bad thing to say?
No, I don't think that that's a bad thing to say. I think you want to be honest with employees about how things are going to work out to the extent that you can. And we'll talk about this a little bit later about the sort of honesty is the best policy. But if an employee is coming to you and says, I want this to be confidential, then better to say, look, why don't you tell me what it is? I can't say that it's going to be confidential depending on what you're telling me, but the point is that we want to get it figured out. We want to address the issue.
Yeah.
Just like if an employee came to you and said, I want to tell you something confidential, and then they told you that they did something illegal, you shouldn't be keeping that to yourself either.
Right.
You want to, as a supervisor, you have that responsibility to your company and to yourself, frankly, that you need to take action on any complaint you get. Okay. I often see cases where an employee says, well, I complained of something and I was harassed. I complained about it. Nobody did anything about it. And then I talk to the company and they say, well, no, that person never complained about anything. We never got any complaint. We don't know anything about any complaint. And as it turns out, when we get down to the supervisor level and talk to the supervisor, they say, well, yeah, she said this, but I didn't, she didn't say anything about harassment, and she, didn't use that word. And she said it was okay, and she said she didn't want to do anything about it, and therefore I didn't. And then there's a problem.
Yeah.
Again, this is a place where having policies can help, because then you can say, look, she didn't follow that policy. Right. But it's still, it creates a problem situation if the supervisor really did know something and they didn't do anything about it.
Now, you mentioned whistleblowers and retaliation.
Yeah.
So that retaliating could be anything like even demoting the person or taking them off a certain project.
It could.
Or moving them within the company. It doesn't just mean they're getting fired.
Right.
It could be any kind of change in their situation.
It could be an adverse action, or even just a sort of a negative in their workplace. The standard under the Minnesota Whistleblower Act has actually, and that's a law that has changed recently as well, and has made it easier for employees to make claims of whistleblowing. And so even very kind of slight changes in someone's work that are that the employee finds to be negative may be considered to be enough to support a retaliation claim. So the way that works is a person has made a complaint of what they perceive to be some illegal conduct. The employer then 3 weeks later starts to have them work nights instead of days. Okay. The employee may say, well, you put me on nights, which I don't want to work nights. And that's days to nights can be a big deal because I made that complaint. And that action is a protected action. So, and this is a tough area, the whistleblower stuff, because you may get that employee. There are those employees out there who are serial complainers. They can always find something to complain about. And at a certain point, it's sort of, they create morale issues, they waste time, they do this, they do that, and I don't want them here anymore. But you have to go back and look, is this really connected back to them making protected complaints and engaging in protected conduct? And you have to disentangle that protected conduct from, is there a real reason beyond that conduct that we want to take a particular action toward this employee?
Got it. Number 4, if you know of a problem, act on it.
Yes. So we kind of talked a little bit about it already. So listen to hear whether there are employee complaints, and if you know about it, do something about it. Again, that the cone of silence doesn't really work for supervisors.
Great.
Yeah.
And moving on, number 3. I guess that means individual supervisor,
yes,
you can be personally liable.
That is true. There are areas in which individual supervisors can be personally liable. So not only do you have the interest of your company to think about, but supervisors also have their own self-interest to think about a little bit. Managerial employees are often brought in as individual defendants in lawsuits where there may be a claim against the employer and against the supervisor, saying this supervisor, for example, committed a tort, like intentional infliction of emotional distress. The supervisor was made my life so miserable, basically, harassed me and took all kinds of actions against me and made my life miserable and caused me to suffer from stomach pains and what have you. And I'm going to bring them in individually. Now, oftentimes that's something that is the company would defend the employee and the company, but if the employee has been not acting in the employee's best interest, the supervisor has been acting against the company's best interest, they're creating a real problem for themselves. And really, you don't want to have your name in a lawsuit anyway.
So pushing that to kind of the ultimate extreme, like if you were sued individually as well as your employer, and the employer decided you were kind of on your own here.
Yeah.
Are you going to have to pay your attorney out of your own pocket usually?
Yeah.
Yeah.
There's the way that a lot of employment laws work, the discrimination laws and the wage and hour laws and many other statutory laws, is that if the employee wins, the employee gets attorney's fees. If the employer wins or the supervisor wins, the employer and supervisors still have to pay their own attorney. So there's a fee shifting, but only in one direction, only in the direction of the employee. So the company is going to be paying their own attorney's fees. And if there's an individual defendant, a manager, that person is going to be paying, or their company is going to be paying for their attorney's fees as well.
Right. Our number 2 top tip. We're getting close to top, so these are the big ones. Number 2, document.
Yes. This is another one where I sometimes have employers tell me, well, we don't want to put this in writing because we don't want to create a paper trail about it. But typically, if you're doing the right thing, you want your paper trail. Another thing that I see sometimes is there's no paper trail, and all of a sudden the person, say, makes a protected complaint, and then all of a sudden everything is documented thereafter. Well, that looks kind of suspicious when the whistleblower ends up filing a lawsuit. That, as soon as I made that complaint, they started scrutinizing me. They were documenting everything I did. They were looking for excuses to fire me. So, and if you have zero documentation and then tons of documentation, well, that's kind of how it looks.
Yes.
Yeah. So be consistent. I really recommend that employers do employee evaluations on at least an annual basis, and do them, again, consistently. Do them if you're going to do them for one person, do them for everyone, and really do them. And resist the temptation for things like grade inflation. Be honest on these things, because they are your documentation. That's where you're going to say, when you're at the point of, say, terminating an employee's employment, look, we've been telling you this for the last 2 years. It's in your review. It's in your other review. Or it's in your review for the last 2 years. It's also, we gave you a verbal warning. We gave you a written warning. Now we gave you a suspension, and now we're firing you. This is not a surprise. A lot of times I think this wards off litigation altogether, because if an employee knew this, they're less likely to go to an attorney and say, I think that this was totally unfair. The attorney may also be less likely to take the case if they see, okay, there's 2 years worth of documentation that's backing this up.
Right.
So having that documentation is important. And doing it, it doesn't all have to be long and involved, but it's important to have that. Now, a little flip side, document. Be careful of email, because email can be discovered in litigation. And so when you're ranting and raving about your employee on email to someone else, that email that you may have sent in the heat of the moment may come up and be, an exhibit that gets blown up on a big screen in a piece of litigation. And that's something that you really don't want. So document and be conscious of what you are putting into any documentation that you write to, from, or about your employees.
So that would include email, texts.
Texts could be.
Voicemail, transcripts, anything, right?
Yep.
Once it's created, it's
Once
kind
it's
of
created,
out there.
It's out there.
And all that is going to be fair game in a lawsuit.
Yep. Yeah. So, sometimes you do hear this sort of, well, we don't want to put anything in writing because we're afraid of how it's going to show up. Well, just do it well.
Yeah, right.
do the
right
when you
thing.
put things in writing, put in writing the things that are truthful and accurate and that you can back up. And it also makes you think about things, as you're putting something down. Okay, I'm going to discipline this person. And as you're thinking about what you would put in the discipline, it helps you to consider, what are the real reasons that you want to discipline the person, and to make sure that you have the backup information, the specifics. Mm-hmm. So we really recommend doing good documentation. I don't recommend overload documentation or sort of micromanagement documentation. You don't need to write down everything an employee does, right. But doing things in sort of a regular sequence, having reviews. If someone is, for example, having poor performance, and you put them on what's called a performance improvement plan. So something that's supposed to help them to get to a point where they can improve their performance. Then you want to perhaps document that, yes, I met with this employee every 2 weeks to try to help them to meet their performance improvement plan. So again, that's a place where you would have some documentation. Right. So having the documentation is really valuable if there is litigation. Now, that's not to say that if there isn't documentation, there's no defense. But having the document is really worth 5 people going up on the stand and saying, yes, it's really true. People seem to tend to believe what they can see on paper, what's put on paper, as in comparison to just what somebody says. Doesn't necessarily make sense, and it doesn't really make it any more or less true. Mm-hmm. But having the documentation can really be very helpful.
Our number 1 top 10 tip for managers is honesty is the best policy.
It is. And it sounds sort of silly, but I'm going to give you a little scenario here. Okay. You have an employee, Mary. Mary's been working for you for 30 years, and she kind of morphed into the human resources person as the company grew. But you've grown from a company of 4 people to a company of 200 people. All of your payroll issues are more complicated. Your HR issues are more complicated now. And Mary really isn't able to do the job anymore. And the job that, although she started out just being an administrative assistant, her most recent title is Director of Human Resources. And she really doesn't have any background in human resources, but she's grown into that role. She's grown into it to a certain degree. And she really isn't able to handle what the company does now. So you need to get in a more professional human resources person who has more background in it and a better understanding and can handle your more complicated business. Well, so obviously you don't want to say to Mary, your performance isn't very good and you don't know how to do this job, and so we're going to let you go. What you want to say is, Mary, we're just going to eliminate this position. We're not going to have this position anymore. We're going to let her go. Don't do it. That's as much as you want to save Mary's feelings and not let her feel like she's a failure, or you feel like, well, she's such a nice person. We've known her forever. She's really, she's like part of the family, but we just can't have her doing this job anymore. And we really don't have another job for her to do. So, but we want to save her feelings. But what happens is Mary, loyal employee that she is, gets told we're eliminating the position. She's a little puzzled, but she says, okay. And she goes off and she finds another job as an administrative assistant someplace doing something else. And then she sees that you hired someone 20 years younger than she is, and are calling them the manager of human resources. And she says, well, wait a minute, you didn't fire me because you just wanted to get this younger person in there and you wanted, and I'm going to sue you for age discrimination. And first of all, you're shocked that Mary would ever do this because you've known her for so long and she was so loyal. But I'll tell you, it happens. And second, you say, okay, well, but we fired her because she couldn't do this job. Her performance wasn't good enough and she doesn't have the background for it. And we have a great reason. But what you've told her is we're eliminating the position. And in an age discrimination lawsuit and a sex discrimination, disability discrimination, or any of these other types of discrimination lawsuits, one of the defenses that you would have is that you let someone go for a legitimate non-discriminatory reason. And you have that. But Mary can then come back and say, that's pretext. That's not the real reason you fired me. And you know what's evidence of pretext? What's evidence of pretext is that you told me a totally different reason for firing me. You told me that my job was eliminated. You didn't tell me that my job was, that I was let go because I wasn't qualified for the job anymore. And so all of a sudden you go from having a really good reason for replacing her to having no reason at all and not having that particular defense.
And having a reason that looks like a pretext.
Having a reason that looks like you were lying.
Right.
And that creates a problem for you in a litigation setting. I mean, the honesty is the best policy works in a lot of other ways in the employment situation as well. As I mentioned before, when you're documenting, resist the urge to grade inflation. Because again, you may have someone and they're tripping along and, they're probably not even satisfactory. But, if you say not satisfactory, that really makes people upset. So satisfactory, but everybody knows that satisfactory really means not satisfactory. So I'm going to give this person excellent on their review, or very good, or whatever the next one up is. Everyone knows that a 3 is just barely getting by. So I'm going to give them a 4, even though they really should be a 2. Well, again, when you get to the point of saying you don't get this promotion because your performance really isn't that good, and they say, but my employment is my performance is very good. You said it. Here it is on the documentation. And which is why sometimes people say, I don't want to document at all because I'm going to get caught by my documentation. But if you're going to document, do it honestly. And then that creates, first of all, it should be helping you to help your employees become better and understand how they can do better in their jobs. But also, there's no shock factor when suddenly someone gets fired or demoted or not promoted, and they can't use your own words against you to say, I'm an excellent employee. You said so in my review. And you say, well, but that was just grade inflation. Well, that doesn't work very well. Even though, you think everybody knows it happens, it doesn't work very well with the employee who thinks she really is excellent because you said it.
Right. But I like the focus that you also brought on. Honest communication does give the employee what they need to possibly improve their performance if they can.
Yes.
If you never say to someone, this is a problem, you're not giving them the information they need to try to work on a certain area or skill.
Yeah. And I think sometimes employers forget that, what they put into employees to get them to a certain place, that rather than firing someone, you want to think about, well, how do I make this person a better employee? Because you as an employer put a lot into the hiring process, bringing someone on, training them, getting them up to speed on your systems, on your programs, on how your workplace works, integrating them into your workforce. And all of that has a cost to the employer. And so really you are often better off trying to train and improve an employee's performance than scrapping that employee and starting over again, where you're going to have to start with those costs again. And you have an unknown, someone who you don't know if they're going to, you may be right in the same position in a year with that employee as with the last one. So, think about your, employees are valuable to companies, and providing them the information and knowledge they need in order to be the best that they can for your company is helpful.
That's great advice. Well, we got to the end of our top 10. I would just want to ask you, Holly, bringing back to our focus on risk management.
Yeah.
If, I know sometimes you hear from clients when something bad has already happened or is about to happen. Is it worth, if you're unsure about whether it's a good time to pick up the phone to talk to your attorney, do you wish people would call you sooner rather than later? Do you feel like people wait too long to bring in?
Absolutely. I mean, most litigation results from something that could have been avoided. And that doesn't mean that the employee wouldn't have been fired ever. It just means that if the process was taken, sometimes the process needed to be taken more slowly. There needed to be a little more patience. Sometimes the documentation needed to be better. Sometimes the communications needed to be done in a different way. But oftentimes, if you get the advice on the front end, you can avoid a much bigger cost on the back end. And litigation isn't something that just has a cost in attorney's fees. It also has a cost in employee time, in the attention that it takes from management. Sometimes it has a cost in publicity. So there are lots of other slightly less tangible costs that are added to just the expense of litigation, which really is quite significant.
Right. Well, thanks, Holly. I really appreciate the time you've taken to come in and share your wisdom with us.
Yeah, thank you. It was fun to talk about.
Thanks very much.
All right.